The affidavit of support is a required form for most family-based green card applications, but this form has many variations: I-864, I-864EZ, I-864W, I-864A. And in today's video, I will briefly talk about each variation of this form and when you need to use it. Hi guys, my name is Kseniya. I make videos for people who are going through the family-based immigration process. I'm not an attorney. My videos are based on public information, my own experience, and the experience of my subscribers. And the purpose of my channel is to give you guys the confidence to go through this process completely on your own. Before we continue further, if you have any questions about the affidavit of support, I highly recommend that you check out my affidavit of support playlist. Let's start with the I-864, the standard affidavit of support form. Like I mentioned in the beginning of this video, this form must be provided in most family-based green card cases, with one exception, which we will talk about at the end of this video. I-864 is completed by the petitioning sponsor, and the petitioning sponsor with this form will prove that he or she has enough income to sponsor the intending immigrants. The petitioning sponsor must file I-864 even if they don't make any money. So even if the petitioning sponsor's income is zero, if they are unemployed, or if their most recent tax returns don't show the appropriate amount enough to sponsor their applicant, in that case, they still must file the affidavit of support. And in the case where the petitioning sponsor does not make enough income, they can ask for help from a co-sponsor. And there are two different types of co-sponsors. There are household members and there are joint sponsors. And I also have a video talking about the different types of co-sponsors, the household members versus joint sponsors, what is the main difference between the two, and what kind of forms they need to fill out, what kind of evidence they need to present. So you definitely want to check out that video because it goes into more detail. So let's quickly talk about joint sponsors. A joint sponsor is someone who is a U.S. citizen or a permanent resident who can take on the entire financial responsibility for sponsoring the immigrant. And the joint sponsor in that case will then have to sign the form I-864 as well. So an additional I-864. I do encourage you to read the form instructions for this form, which does describe who can be a joint sponsor. But for the purposes of this video, you need to know that the standard affidavit of support form is filled out in two main situations. Either one by the petitioning sponsor or two, a joint sponsor. There are additional very rare circumstances where I-864 must be filled out, but in majority of cases, this is the only two reasons why this form is used. Now, let's talk about I-864A. And this form is called Contract Between Sponsor and Household Member. I want to pay your attention to the name of this particular form. It is called Contract Between Sponsor and Household Member, and it is not called Contract Between Petitioner and Household Member. This is because a household member can be attached to anyone who fills out the form I-864. And if you remember just a minute ago, we talked about how this standard I-864 form is filled out either by the petitioner or the joint sponsor. So either the petitioner or the joint sponsor can have their own household members. This often does happen in a situation where either the petitioning sponsor doesn't work, but their spouse does, for example, and they need help sponsoring their parents, for instance. In that case, the petitioning sponsor's spouse can be their household member and then fill out the form I-864A. But there are situations, like we mentioned before, where the petitioning sponsor doesn't make any money and doesn't really have or want to use their household members, and they ask a joint sponsor to sign the additional affidavit of support. But if the joint sponsor wants to or has household members who would like to contribute their income, then the joint sponsor's household members will fill out I-864A. If you have any questions about I-864A, once again, check out the playlist that I mentioned at the top of this video. Let's talk about the next variation of the affidavit of support, and that is the form I-864EZ. And just like its name, it sounds as an easier version of the affidavit of support. This easier version of the affidavit of support can be used in very specific circumstances, but I personally feel like not enough people take advantage of this form. The I-864EZ form is used by the petitioning sponsors only, and they must meet certain conditions in order to be able to use this form. These conditions are described in the form instructions as well as on the very first page of the actual form. The petitioning sponsor must be able to solely rely on their own W-2 income or retirement income. So, petitioning sponsors who are self-employed or business owners may not necessarily fit into this guideline. And the other condition that the sponsor must meet is that they're only sponsoring the relative who does not have derivative applicants. And that could confuse some applicants who think that because they have dependent children, that they're ineligible to apply for this form. Keep in mind that derivatives are not the same as dependents necessarily. I do encourage you to read the I-130 form instructions on the first and second page. USCIS does spell out which relative categories can and cannot have derivative applicants, such as unmarried children under the age 21 and spouses of the applicant who are included on the same petition. But in the case where you are petitioning multiple relatives under entirely different petitions, you should be able to use the I-864EZ form as long as you meet all the other conditions. So if you are a U.S. citizen petitioner who is petitioning his or her parents and you hold a regular W-2 job, you are very likely to be able to use I-864EZ. You also may be able to easily use this form if you are going through a marriage-based green card case. And if you are applying for adjustment of status based on a prior fiancé petition, the I-129F, that also included K2 derivatives that arrived with your fiance, then in that case, you will not be able to use I-864EZ because any derivative K2 applicants must be included in the affidavit of support. So for that reason, you will be using the regular I-864 form and in the appropriate part, including the names of all the derivatives. And finally, let's talk about the exception to the affidavit of support that I mentioned in the beginning of this video. So like we said before, in majority of family-based green card cases, the petitioning sponsor must fill out the affidavit of support. However, there are cases where you may be able to be exempt from the affidavit of support entirely by submitting the form I-864W. This exemption is available for quite a few reasons, but in this video, I want to mention two main reasons when you might be able to use 864W. The first reason is if your beneficiary, so the person who is immigrating to the United States, has earned 40 Social Security credits with the Social Security Administration. This could happen in a case where your beneficiary has been living in the United States and working here for a significant amount of time. So by the time you file a family-based green card case, your beneficiary may already have earned 40 Social Security credits. If you are the kind of applicant who has been living in the United States and legally working in the United States with proper work authorization, if you are the primary breadwinner in your family and your petitioning sponsor doesn't make enough income. If you are able to take advantage of this kind of form, you can avoid having your petitioner ask for a joint sponsor and navigating that complication in the first place. In general guidelines, 40 Social Security credits equal to about 10 years of work in the United States, but that is not always the case. There are ways of combining credits with your spouse for the purposes of meeting this 40 credit requirement. Another reason why you might be able to use the I-864W is if you have any children who, upon receiving their green card, will automatically become U.S. citizens. For example, you have naturalized and you decided to petition your children. If these children are still under the age 18, once they become permanent residents, because you are already a citizen, they will also then automatically become U.S. citizens. Keeping that in mind, at the time of you filing their green card application, you may be able to just submit I-864W instead. But that does require you to sit and analyze your case. A lot of applicants do end up just submitting the regular I-864 form for their children, and that is not really a mistake. USCIS will still process your case and will accept the regular I-864 form. When it comes to the consular process, the NVC is actually pretty good about notifying applicants when they should be submitting I-864W for minor children applicants. In terms of I-864W for people who have earned Social Security credits, it's also not a mistake if you choose not to use this form and if you just choose to submit a regular affidavit of support. Although I do think that not enough people take advantage of this kind of application. So, these are the 4 variations of the affidavit of support. I hope that you found this video useful. Subscribe to my channel if you haven't already. Give this video a thumbs up, and I hope to see you guys in my next video. Bye!